Welcome. My name is Reuben Tylor. I'm a New Zealand barrister and I'm a director and shareholder of Trustees and Fiduciaries. Today I'm going to give you an introduction to asset protection and in particular Cook Islands Asset Protection Trusts. The Cook Islands Asset Protection Trust laws were developed by myself together with US attorneys in 1989. The concepts were developed with US clients in mind in direct response to a couple of things that are rather unique to the United States, and that is one, the prolific nature of litigation in the US, and secondly, various doctrines under US law which expose trust assets to personal creditors. Cook Islands Asset Protection Law gave clients the first comprehensive asset protection regime. It provided certainty for settlers. It protected trust assets against unwarranted litigation. In the 30 plus years since our law was passed, our law has been copied in several jurisdictions, including various states in the United States. But the Cook Islands retains its position as the premier asset protection jurisdiction. So what is asset protection planning about? It's a method of putting a fence around your existing assets to quarantine them from future creditors. Asset protection planning allows you to exercise a degree of control over those assets. It allows you to continue to enjoy the benefit from those assets, and it allows you to add further surplus assets into the fence from time to time. It's similar in a way to insurance in that it provides protection against a future event, but unlike insurance, it does not attract litigation, it repels it. What is asset protection planning not about? Well, it's not about hiding assets, in particular not about hiding assets from federal authorities or from the IRS. It's also not about hiding proceeds of crime. In fact, the success of Cook Islands Asset Protection Trust depends on disclosing the existence of the asset protection at an early stage of any litigation, and that is when it relies on the strength of protective Cook Islands law. Who might benefit from asset protection planning? There's several categories of clients who typically form asset protection trusts. The first category are people that own real estate or have owned real estate in the past. Real estate carries substantial risk of liability. A second category are business vendors. When you sell a business, you will be giving vendors warranties, and those will be particularly important if you are entering retirement. Another category is people of high wealth. They can expect litigation simply because they have that high wealth. Clients who are about to marry often enter into prenuptial agreements. Part of the planning for a prenuptial might also include the establishment of an asset protection trust. And finally, when you are estate planning for a wealthy family, you need to take into account that you are not just planning to protect the assets in the hands of the first generation, but there are subsequent generations who may also be exposed to risk. So that risk might be, for example, from the spouses of your children or your grandchildren. So those are some typical client profiles. I think it's also important to understand that asset protection is not just about offshore asset protection trusts. There are also several asset protection planning techniques available in your domestic jurisdiction. If you have a look at this diagram, you will see at the bottom of the pyramid is joint ownership, which provides the lowest level of protection. Above that is liability insurance planning, but of course the weakness in that is the small print. Pensions and life insurance have specific asset protection legislation protecting them against your personal creditors. You also have the choice of domestic asset protection trusts in some of the US states, although they also have their weaknesses. And at the top of the pyramid with the highest level of protection are foreign law asset protection trusts. So what are the advantages of settling an asset protection trust in the Cook Islands? I think the first and most important point is that our law is the most comprehensive regime that you will find for asset protection trusts. You need to remember that asset protection is the dominant activity in the offshore jurisdiction in the Cook Islands. It is not an add-on to other activities. We also have an excellent judiciary, with our judges being appointed from New Zealand's Senior Court of Appeal judges. Finally, we have a good track record, and that track record is that our laws have been enforced since 1989. We have a government policy that has been consistent throughout that period. Our judges understand the law and the issues, and our trustee companies understand what role they should play, and they also have in-house legal experience.